Thank you, Senator, so much. Thank you, Chairman Inhofe and Schuster, ranking members Boxer and DeFazio, and members of the committee for the opportunity to testify today on the waters of the United States proposed rule and the potential impact on state and local governments. My name is Sallie Clark, and I am the first Vice President of the National Association of Counties, the only national organization that represents county governments. For the past decade, I've served as a county commissioner in El Paso County, Colorado, the home of Pikes Peak. My county is considered urban with a population of over 640,000, but with a mix of suburban and rural areas and over 113,000 acres of federal land. In all my travels as a NACO leader, I've heard concerns from across the country about how counties could be affected by the proposed rule. Hearing these concerns and working closely with our technical experts, county engineers, legal staff, public works directors, and stormwater managers, NACO ultimately called for the proposed rule to be withdrawn until further analysis and consultation with local officials is completed. This decision was not taken lightly. I want to be clear, counties support clean water. Our goal is to ensure the public safety and economic vitality of our communities while protecting water quality. In my county and others, we accomplish this through zoning and ordinances, regulating stormwater runoff, prohibiting illegal discharges, and establishing penalties for violations. That said, I'm here today to share with you the 4 main reasons we decided to call for the withdrawal of this proposed rule. First, this issue is so important because counties build, own, and maintain a significant portion of public safety infrastructure, and the proposed rule would have direct and extensive implications. Local governments own almost 80% of all public road miles and also own and maintain roadside ditches, flood control channels, stormwater systems, and culverts. Defining which waters and conveyances fall under federal jurisdiction has a direct impact on counties, as we are legally responsible for maintaining public safety ditches and other infrastructure. Second, the agencies developing the proposed rule did not sufficiently consult with local governments. Counties are not just stakeholders in this discussion. We are partners in our nation's intergovernmental system. By law, federal agencies are required to consult with their state and local partners before a rule is published and throughout its development. Although EPA did initiate discussions on guidance documents, we were not consulted through the 17 months between the guidance consultation and the introduction of the proposed rule, despite repeated requests. This leads to my third point. Due to this inadequate consultation, many terms in the proposed rule are vague and create uncertainty and confusion at the local level. For example, the proposed rule now defines terms like tributary, significant nexus, adjacency, riparian areas, and floodplains. Depending on how these terms are interpreted, additional public infrastructure could fall under federal jurisdiction. The proposed rule, as currently written, only adds to the confusion and uncertainty over how it would be implemented consistently across all regions. Our fourth and final reason for calling for the withdrawal is that the current permitting process tied to waters of the U.S. already presents significant challenges for counties. The proposed rule only complicates matters. For example, one Florida county applied for 18 maintenance exemptions on the county's network of drainage ditches and canals. The permitting process became so cumbersome that the county had to hire a consultant to compile all of the technical material required. And 3 months later, as the county moved into its rainy season, and after spending more than $500,000 invested, decisions on 16 of the exemptions were still pending. Ditches began to flood, putting the public at risk, and this is just one of many examples. In conclusion, while many have attempted to paint this as a political issue, in the eyes of county government, this is a matter of practicality and partnership. We look forward to working with you and the agencies to craft a clear and workable definition of waters of the U.S. that achieves our shared goal which is to protect water quality without inhibiting the public safety and economic vitality of our communities. Thank you again for this opportunity.
Thank you. Mr. Mock, the floor is yours. Welcome.
Thank you. Chairman Inhofe, Schuster, Ranking Members Boxer and DeFazio, I appreciate this opportunity to testify. My name is Timothy Mock. I was elected to the Clear Creek Board of County Commissioners in 2010 and re-elected in 2014. As a county commissioner, I want to convey how important clean water is for my community. The proposed clean water rule will protect the headwaters, tributaries, and wetlands that are essential for providing the high-quality water that supports the hunting, fishing, rafting, and outdoor recreation that are an economic backbone of my community. Clean water from streams and wetlands also provide drinking water for thousands of our residents. Clear Creek County is truly a headwater county. We are bordered by the Continental Divide and provide clean water for downstream communities within the Denver metropolitan area. We are also facing the legacy impacts of historic silver and gold mining. We have struggled with maintaining water quality due to mine runoff and have worked consistently to treat contaminated water and reclaim abandoned mine sites. I know too well the impacts of contaminated water and the costs and time it takes to mitigate and treat it. I also know Clear Creek has made a remarkable rebound over the past 30 years, as we have all made progress, like so much of the country, toward the Clean Water Act goals of fishable, swimmable waters. In addition, these strides in water quality, while important in their own right, have also made Clear Creek County an outdoor recreation destination. By river segment, Clear Creek hosts the second most commercial rafting trips in Colorado. Whitewater rafting alone has a total economic impact to the community of approximately $23 million annually. Hunting and angling generates a total economic impact of nearly $6 million to the county. This is not only the story of Clear Creek, but also across Colorado and the nation. According to the National Shooting Sports Foundation, hunting and angling's total economic impact is $192 billion. Outdoor recreation in Colorado generates $13.2 billion and employs more than 124,000 people. Across the country, it generates $646 billion and 6.1 million jobs. Many of these jobs are dependent on clean water and will benefit from the EPA and Army Corps of Engineers efforts. In fact, 55% of stream miles in the historic range of native trout in our state are intermittent or ephemeral and would clearly be protected by the Clean Water Rule. Even with seasonal flows, these waters provide habitat for trout or simply maintain the water quality needed by fish in downstream rivers. And as an avid waterfowler, I've spent many cold mornings in the wetlands, sloughs, and creeks feeding the South Platte and know how important it is to protect these places from irresponsible development. As an elected official with the responsibility of looking after our county's finances, I am also concerned about undue regulatory burden. The EPA and Corps of Engineers have consistently demonstrated that this rule is not an expansion of the Clean Water Act authority. It will restore jurisdiction to fewer of the waters than had been covered from the passage of the Clean Water Act in 1972 until the first Supreme Court decision in 2001 weakened the law. During that time period, the population of Clear Creek County increased from approximately 5,900 to 9,400 individuals. Colorado's population doubled from 2.2 to 4.4 million. The state's gross domestic product increased more than tenfold from 13.6 to $181 billion. Furthermore, natural gas production increased from 116 trillion cubic feet to 817 trillion cubic feet, and coal production increased from 5,500 short tons to 33,000 tons. Although we are small, we are expected to grow in the future. An expansion of Interstate 70 is underway, and along with it, a growth in home and road development from those from the nearby metropolitan areas seeking solace in the mountains. In addition, we face a challenge of economic diversification as we approach the end of life of the Henderson mine, which provides a large portion of our property tax base. There are hundreds of mine claims that exist in undeveloped or undeveloped areas many of which are very near headwater streams. The rule will help us balance the need for diversification while providing the necessary protection for streams and wetlands as we encourage development of all kinds. If opponents of the rule were worried about returning to the previous jurisdiction of the Clean Water Act, they should realize that protecting intermittent and ephemeral streams and wetlands is fully consistent with population growth, energy production, and economic development writ large. I am ready to have my county's headwaters and wetlands clearly protected under the Clean Water Act. Thank you, Mr. Chairman.
Mr. Sirolovic, welcome. The floor is yours.
Thank you. Good afternoon, Chairman Inhofe and Schuster, ranking members Boxer and DeFazio, and members of both honorable committees. I am Lem Shrolovic, the Environmental Bureau Chief in the Office of New York State Attorney General Eric Schneiderman. Thank you for this opportunity to discuss with you the proposed waters of the U.S. rule. Back when I was a boy, growing up in Wildwood, Georgia, in the early 1970s, many of the creeks and rivers where I hunted and fished were in a sorry state. The Tennessee River was contaminated with toxic industrial waste. When my brother and I floated down Lookout Creek, it started stinking when we reached the railway yards in Wauhatchie. But the pollution problems in my boyhood waters were not local, they were not regional problems, they were national problems. Up in New York, the Bronx River, once the home of beavers, was described as an open sewer. In central New York, people driving by Onondaga Lake during the summer rolled up their windows because the lake smelled so bad. Fortunately, Congress responded, and in 1972 passed the Clean Water Act. With the act, Congress fundamentally rewrote federal water pollution control law. The old law had addressed water pollution by authorizing federal cures for water pollution problems on an ad hoc, water by water, problem by problem basis. But that narrow approach had failed. With the Clean Water Act, Congress replaced that failed scheme with a comprehensive approach to pollution control. The waters protected by the Act are broad, covering, as the U.S. Supreme Court has written, virtually all surface waters in the country. With the Act, Congress implemented the tried and true principle that an ounce of prevention is worth a pound of cure. In the ensuing years, the states, EPA, and the U.S. Army Corps together have implemented the statute, and it is working. My boyhood Lookout Creek now hosts a popular nature center. A beaver has returned to the Bronx River, and Onondaga Lake now is one of America's top 10 bass fishing destinations. With the proposed rule, the federal agencies that Congress charged with implementing the Clean Water Act are doing their job. They are providing much needed clarification to the question whether the law applies to a particular water body. Presently, jurisdiction decisions are made on a case-by-case basis, subject to fractured and inconsistent legal interpretation by the courts. The result is uncertainty, delay, and further litigation. By clarifying where the law applies, the rule will accelerate jurisdiction decisions and make them more predictable and less costly. The proposed rule is grounded in solid peer-reviewed science. EPA's science report is based on more than 1,200 peer-reviewed scientific studies and has been affirmed by the agency's independent scientific advisory board. The science report shows the powerful influence that upstream waters have on the physical, chemical, and biological integrity of downstream waters. It is important to note that each of the continental states is both upstream and downstream of one or more other state. New York, for example, is downstream of 13 states and is upstream of 19. The proposed rule advances the Clean Water Act's protection of state waters downstream of other states by anchoring a nationwide federal floor for water pollution control. The floor is critical for maintaining the consistency and effectiveness of the downstream states' water pollution programs. This is because the federal statute preempts many common law remedies traditionally used to address interstate water pollution, leaving the Clean Water Act as the primary mechanism for protecting downstream states from the effects of upstream pollution. Critically, by protecting interstate waters, the proposed rule allows states to avoid imposing disproportionate and costly limits on dischargers in their own state in order to offset upstream discharges which might otherwise go unregulated. A robust Clean Water Act is important to states and municipalities because by protecting our waters, it keeps billions of dollars in taxpayers' pockets and supports our state economies. In the interests of clean water, the health and welfare of our citizens, and the economy of our states, we should not go back to failed approaches. We should go forward with what is working. The Waters of the United States rule provides much needed clarification regarding the applicability of the Act and anchors an essential nationwide federal floor for water pollution control. We look forward to the completion of a final rule, and I look forward to answering any questions.
Thank you. I recognize Senator Inhofe for 5 minutes. Thank you.
Thank you, Mr. Chairman. I'll start off with my good friend Scott Pruitt. Now, confession's good for the soul. I'm not a lawyer, and so I have to ask some obvious questions of people who are lawyers. Now, I'm going to read something, and tell me, if you would, in general, what is ambiguous about this language. Section 101G of the CWA states, and this is a quote, it says, the authority of each state to allocate quantities of water within its jurisdiction and that shall not be superseded, abrogated, or otherwise impaired by this act. What's unclear about that?
Well, Mr. Chairman, I don't think much, and I don't think that it takes a legal mind to draw that conclusion. I would add this as well. The CWA states in its text that agencies must recognize, preserve, and protect the primary responsibilities and rights of states to plan the development and use of land and water resources. This body, Congress, recognized at the creation of the Clean Water Act that the role of the states was important, but more than important, it was primary in land use and water management decisions. In the state of Oklahoma, we have a Water Resources Board that is required to measure out permits to those that seek to use water in the state. We have a DEQ that is consistently involved in water quality issues. The decision and the discussion here today is not whether the EPA has any role in the process. They in fact do, but they only have a role when we have navigable waters, interconnectivity, because jurisdiction is at issue here, Mr. Chairman, and I think the EPA, through this redefining of waters in the United States, is seeking to extend its authority to displace and duplicate the state's authority.
Yeah, you know, both Commissioner Putnam and Commissioner Clark both said statements to the effect that we in Colorado, we in Florida want clean land, we want clean air, we want clean water. Why do you feel it's necessary to reaffirm that? And I won't ask you to answer it because I'll answer it for you. There's this assumption that no decisions are good decisions unless they're made in Washington. And whether you picked it up or not during the opening statement of the first panel, they feel, and those individuals who are embracing their new authorities that they're seeking are ones who do not believe that you are capable in the states to do as good a job as they would do in the federal government.
Well, Senator, I think in many instances, even beyond the Clean Water Act, there are those in Washington that populate the EPA and other agencies that see the states as a mere vessel of federal will. And so long as the states agree with the view and the perspective of the agencies here, there is no conflict. But when there is disagreement about how decisions should be made, and I would add this, decisions that have been reserved by this body, by Congress to the states, that is when the competition and the conflict arises, and that's what we have here. We have a situation where the EPA is extending its authority into areas that are historically, and I might say almost exclusively, the purview of the states, and they're doing so because they want to dictate to the states how we should manage our water and use our water.
Well, and I appreciate that. We live with this on a daily basis. There's some other language in here I'm going to ask the three of you to respond to, because when I first read this, I know how I interpret it. It says that agencies have told states that these rules will not actually provide any certainty because most of the decisions are left to the, quote, best professional judgment of the EPA and the Corps of Engineers. What do you think about that language?
Well, I think that, and also what the commissioner mentioned, Mr. Chairman, about the catch-all category. There is a catch-all category the EPA is proposing with this rule that they say the purpose is to provide transparency and predictability and consistency with respect to the scope of the CWA, but when it's reduced down to the discretion, the judgment on a case-by-case basis, that definitely does not provide certainty and predictability to those folks that are regulated across the country. You know, the greatest benefit that we have of rule of law and regulation is that those that are subject to regulation know what to expect and know how to conform their conduct. And when we have decisions made on a case-by-case basis, that is almost impossible to happen. And so, Senator, I'm very concerned not only about what you've raised, but also this catch-all category that we've already identified.
Yeah, and do Commissioners Putnam and Clark, does that phrase concern you as much as it does me?
Thank you. Thank you, Senator. Yes, it does. I think, and I heard the EPA this morning even say that it was confusing. There were a lot of components that are still confusing. It broadens the number of county maintained public safety dishes and infrastructure that would require Section 401 or 404 federal permits. And it's a process that's already cumbersome. There are counties across the nation that I can look to examples where it's increased the length of time. The clarity is a problem, is how it's being enforced by regions as well as the headquarters. And I think we heard today that very thing, that there's ambiguity and clarification, and we need to be at the table to help solve that problem.
Thank you.
Ms. Napolitano, floor is yours.
Thank you, Mr. Chairman. There's an area that we really haven't delved into, and that's the cost of inactivity. And I'd like to ask either Mr. Mock or Mr. Srolovic, sorry. Several comments on the proposed rules have expressed concern about the cost associated with the rule. But in your personal view or that of your organization, is there a cost associated with the inactivity or when compared to the existing rule?
Thank you. I believe there is a cost, and I think the cost is positive. As things exist now, there is fractured, conflicting case law. The courts have invited the agencies to clarify that through a rulemaking, and so I think that as time goes by and the status quo remains, there will be a continuing cost in greater delay of jurisdiction. I think the rule will very much help clarify when, in most cases, the law applies and when it does not. It's not perfect. It's undergoing further work. There's been a lot of comments, but I think it will help bring down the costs over the status quo.
Mr. Moore.
Yeah, if I may, thank you for the question. As a headwater county, we're consistently under scrutiny in terms of the water and the water quality that flows out of our county and downstream to other users. And for a small county, the treatment of that water continues to increase and becomes very expensive for us. And the assurances that we could put in place to assure the intermittent streams, the headwaters, especially in a former mining community like mine, or where we still have sites out there, that the water that is coming down from those streams are protected. The cleaner that water is coming into our systems, the cheaper it is for us, and easier for us to send better quality down the hill.
Thank you, sir. Mr. Srolovic, sorry. A suggestion has been made that New York State is opposed to the rulemaking, and is this position true?
Congresswoman, I think there's 2 points here. The answer is no. New York is not opposed to the rule. Our Environment and Agricultural Commissioner in New York strongly support agency rulemaking to anchor a federal water pollution control floor on a national level. which is essential to protect states from upstream pollution. The commissioners raised some concerns about the lack of pre-rulemaking consultation with states and some of the definitions of certain terms in the proposed rule. While consultation before is always better than after, the Corps and EPA have undertook significant outreach to states, municipalities, and other stakeholders, holding some 400 meetings around the country. One of those was in Worcester, Massachusetts, where our office participated and gave views, along with many others, about these definitions and the importance of the rule. So the agencies also extended their public comment period twice and have taken strides to listen to everyone and craft a better, clearer rule.
Thank you, Mr. Mock.
I'm sorry, could you repeat the question?
Well, the question to you would be the opponents of the rule argue that the process was flawed, that the concerns of state and local governments were not adequately addressed. Were you given ample time and opportunity? I know that they've held, like Mr. Srolovich was indicating, for over 400 meetings, etc. Was there ample opportunity for input?
Yes, this is, there have been these discussions have been ongoing for a number of years now, but there was a very lengthy 200 days for public comment. I believe we've received, or there have been about 1 million comments. I feel like I have had adequate time. I've been able to, over the past year, actually address this through letters to the editor, as a matter of fact. So, absolutely.
Thank you, Mr. Chair. Yield back.
I'll yield 5 minutes to myself. Mr. Solovic, sorry about that.
Sorry about that tough name.
In your testimony, you talk a lot about the need for clarification, and I think there's all agreement on that, on CWA. But however, I find it interesting. I'm looking at the comments made by New York State from the Environmental Department and the Agricultural Department, filed on November 13, 2014, and they're very concerned about the definitional concerns in the proposed rule that prevents New York from providing meaningful comments, the impact of the proposal, economic impacts. A one-size-fits-all approach to redefining the regulated waters will only lead to legal challenges, cause unnecessary harm to farmers, and could lead to other unintended consequences. And they question the process was inadequate because they weren't consulted enough. So I guess my question is, are you aware of those comments? I think you are. And did you consult with these state agencies, or that's being representing the Attorney General's office of the state of New York?
We do represent the state agencies in court and on other legal issues. I think the fundamental point raised by the commissioners in that letter was that while there is a need for a rule, it is very important for that rule to have as much clarity in its terms as possible, and at the same time maintain a flexibility that reflects regional differences. In New York, we have a lot of water. We're blessed with a lot of water. We have a lot of wetlands. Other states, Colorado, very different circumstance.
Yeah, one-size-fits-all policy. I don't think, especially with water. But do you agree with these two state agencies in your state that this proposal would be an expansion of the regulatory authority of the U.S. EPA under the Clean Water Act?
We do not see it as a significant expansion of the jurisdiction of the waters of the United States. We think it codifies the principles that have been applied, that it properly interprets the guidance that a majority of justices have provided from the U.S. Supreme Court, and is an important step forward.
Okay. I guess for the other panelists, cost to the counties, states, this rule as proposed goes into effect. What's it going to do to the cost that you see for your cost of government for local governments?
Thank you, Mr. Chairman. I'll try and go first and be brief. Financially, actually, it is reaching farther out based on the ambiguity and the confusion that's been placed on the rules. If you look at the Small Business Administration's Office of Advocacy, and the analysis that they did, there will be a cost, not just to small businesses, but to small counties, 50,000 or less, and that makes up about 2/3 of the nation's population. In addition to that, if we look back and look at the delay of projects is a cost to us locally. The longer we delay, then it puts safety at risk, it puts water at risk, frankly, and water quality. And then the other component of that really is to look back and see when the EPA did their analysis and what data they used. And it was older data. It wasn't based on today's costs in place. So yes, there is a significant cost.
I want to get to one more question here. So I'm a firm believer that the CWA was put into place because we had major problems. Point source, you saw it in the earlier panel, the Cuyahoga River and all that. And it was structured to be a cooperative federalism between the states and the feds. And with the federal government being oversight and guidance, that's why the states have to submit the 3-year plan of action. So maybe Mr. Pruitt or Mr. Putman might want to comment on how that partnership's been working or not working, or what the process has been, just of implementing and enforcing the Clean Water Act.
I'll be brief. The answer to your first question, we know from urban counties just on stormwater and from an agricultural perspective, the number is easily in the billions. 20% increase in jurisdictional wetlands minimum. We know from the previous study that's now 12 years old that it costs over $300,000 to get a 404. And we know the wetlands mitigation is $100,000 per acre to mitigate. So when you grow the impacted areas and you add the regulatory cost and you add the mitigation factors, it's easily in the billions, not only for ag, but also for our counties. And I'll let my Attorney General friend speak to the partnership issue.
Mr. Chairman, I think that is the concern that you've identified. I think historically the relationship has been strong. I mean, in Oklahoma, we have water quality issues. The Illinois River in the eastern part of our state, there have been ongoing concerns between Arkansas and Oklahoma about phosphorus load in that body of water. Both the EPA has been concerned about that, but so has the state of Oklahoma. We've actually negotiated a memorandum of understanding with Arkansas, and we have worked on both sides of the border to take regulatory steps to reduce phosphorus levels in the Illinois River. And so I think you see examples both at the state level and at the federal level, concern about water quality. But here, my comments to the panel and to the committee are focused more upon this expanded view of the definition that gives the EPA jurisdiction to interpose itself into those areas that are traditional, historical, and I believe lawful to the states on primacy. And that's what we're seeing with this expanded definition, Mr. Chairman.
Thank you. Mr. Duncan, you're recognized.
Thank you, Mr. Chairman. The Rapanos clean water decision was mentioned when I was here this morning briefly. Let me read what the federal district judge said in that case. He said, "I don't know if it's just a coincidence that I just sentenced Mr. Gonzalez, a person selling dope on the streets of America. He's here illegally. He's not an American citizen. He has a prior criminal record. So here we have a person who comes to the United States and commits crimes of selling dope, and the government asked me to put him in prison for 10 months. And then we have an American citizen who buys land, pays for it with his own money, and he moves some sand from one end to the other, and the government wants me to give him 63 months in prison." And this federal district judge said, "Now that isn't our system gone crazy. I don't know what is, and I'm not going to do it." Well, he was reversed. But it shows you can take any of these laws too far. And I can tell you no one is talking about doing away with the Clean Water Act or going back to where we were in 1970. But it's also ridiculous to act like we haven't made any progress and that things are worse now than they were in the 70s, so we have to make these rules even tougher. And I remember when I chaired this subcommittee, the mayor of Los Angeles came to me and he said the EPA was coming down with some new regulations about grease. And he said, "We've got over 10,000 restaurants in Los Angeles." He said, "Most of them are small mom and pop restaurants." He said, "This is going to run several thousand of those small mom and pops out of business." And we got that stopped. But I can tell you that people sit up here in Washington and they write these rules and regulations. They're mostly people who've spent their entire careers in government. Many of them have spent their entire careers here. They don't realize the effect that these rules and regulations, most of them help the big giants in the industry, but they really hurt the small farmers and the small ranchers and the small businesses. And in fact, the SBA said of this rule that we're talking about, the SBA Office of Advocacy put out this statement. It said, small businesses are extremely concerned about the rule as proposed. The rule will have a direct and potentially costly impact on small businesses. The limited economic analysis which the agency submitted with the rule provides ample evidence of a potentially significant economic impact. And I noticed in the biographies, I was here for an hour this morning, and I listened to Administrator McCarthy and Secretary Darcy, and I noticed in their biographies, neither one of them has ever managed a farm or a ranch or been in a small business. They just don't understand the pressures and how difficult these positions, these jobs are, and how tough it is when you have to fight ordinary competition, but then you have to take on your government with unlimited, that has unlimited funds, when you have to take them on to boot. And then people wonder why so many small and medium-sized businesses go out of business. And all these college graduates wonder why we have so many of them working as waiters and waitresses in restaurants, because we've sent millions of good jobs to other countries for the last 40 years or so. And a lot of it, an awful lot of it, is because of the environmental rules and regulations and red tape. And if we don't wake up and realize that, we're going to keep hurting these small businesses, these small ranches, these small farms. And I just get sick and tired of these bureaucrats sitting up here coming up with these rules and regulations that they have no understanding of who it's going to hurt, how much effect it's going to have. I remember when I chaired this subcommittee, we had a cranberry farmer from Massachusetts who broke down in tears talking about the effect that some of these EPA clean water rules were already having on his farm, and to come in and expand them at this point now is just wrong in my opinion, and so I'm opposed to it. And I noticed that almost all the small business groups and almost all the agriculture and farm groups are opposed to it too. Finally, I'll just say I think I'm the only one here that's served with Secretary Putnam. He was a great member of Congress, and he's got a great future ahead of him in the state of Florida. I also had the privilege of serving General with your governor, and she was a fine member, an outstanding member of this body also, and I'm real proud of the work she's doing as your governor. Mr. Chairman, thank you very much.
Mr. Okita, 5 minutes.
Well, thank you, Chairman. It's great to be on your subcommittee. Appreciate being here. As you can tell, I'm new to the Transportation Infrastructure Committee. That might explain the gap here.
Well, this was full committee hearing here.
Right. Panel 1, where all the hubbub was, which, Secretary, that's where I had the plague. I had the plague earlier this morning, but I'm here now. I really enjoyed being this close because I got to really focus in on each of your testimonies and appreciate them. As former Indiana Secretary of State, I really look to county government to help solve our problems, just like I think Washington should be looking to the states to do the same. In fact, I was in Colorado where I learned about vote centers from one of your counties. And I know several Indiana clerks are members of NACO. And we took vote centers back to Indiana and implemented them there. It was good stuff. In that vein, I'm surprised to hear a local official like you, Commissioner Mock, look to the federal government almost solely to solve your problems. And that's what I got from your testimony, whether it was the clean water or the wildlife that helps that the water helps flourish. I couldn't understand when I was listening to your testimony why you, as a elected official, feel powerless to solve these problems yourself or to go to your state legislature. Now remember, before you answer, unless Senator Gardner was wrong, and feel free to correct him, all water flows out of Colorado, right? So you're in almost a unique or particularly good situation to take care of this situation. Why won't you?
Well, like I said in my testimony, Clear Creek County does. We do take an opportunity. We work with the Watershed Foundation to clean up a lot of our waters.
What's the need?
Above us.
What's the need to expand this definition?
The need is the uncertainty, the regulatory uncertainty in terms of what waters are in, what waters are out, the delays in the permitting as we work
Yeah, I
through
want
these
to talk
issues.
about the delay. Your testimony about the delays in the permitting. This expands the jurisdiction of the agency over water. So by definition, you're going to get more permits. So how is getting more permits, because there's going to be more water under jurisdiction, going to speed up the permitting process?
Well,
The last thing they want to give these agencies, and I don't just mean the EPA, but they all seem pretty inept in terms of turning work product around. Why would we give them more paperwork?
and it's my understanding that this does not expand the jurisdiction of the
Why do
Clean
you
Water
think
Act.
that? Oh, doesn't expand the jurisdiction.
Does not is my
Yeah,
understanding.
you state that in your testimony too, but on the other hand, you suggest that the rule would protect intermittent ephemeral streams and wetlands that are currently not federally regulated. Don't these arguments contradict each other?
Well, they were once regulated before, and I think there's more certainty back then with the 2001 and 2006 court rulings. We've kind of entered this gray area now, where we don't exactly understand what is and what is not. Now, I'm dealing with a small business community that's outdoor recreation centric, and the small mom and pop delis and ice cream shops that operate on the backs of the rafting companies, the outfitter companies, the people that come in to camp and recreate and fish and angle. Not having certain protections in place or not being clear to me is rolling the dice on that outdoor recreation industry. And for me, that's all I have after the Henderson mine for my community. But it's a very robust economic engine for not only Colorado, but also the rest
Why
of the
can't
nation.
a county commission ordinance take care of this? Why can't you legislate this yourself?
I can't speak to the legalities. I'm not an attorney. I
No,
think
legality,
that's a good
federalism.
question.
It's not a legality. It's
No,
called
it's
sovereignty of a state. And in your situation, sovereignty of a county. And you've been elected by people to act. And it sounds like what you're doing is saying exactly what Attorney General Pruitt was trying to get at, where there's people in this country that unfortunately think they have to be vessels of the federal government. And I'm going to let Attorney General Pruitt comment on that, and Secretary Putnam. We have about 30 seconds. If you can divide that, and I appreciate your testimony. I want to see if you have anything to add to this exchange we just had.
Well, I do want to provide a comment with respect to the case law just momentarily. There's been two recent decisions: the Solid Waste Agency of Northern Cook County, and also the Rapinas decision that's already been highlighted. And in the Swant decision, the court held that the Corps of Engineers exceeded its authority by attempting to regulate non-navigable, isolated interstate waters. In the Rapinas decisions, they held that the Corps waters must be navigable waters, or at least reasonably made to be so. There's a reason for that. It's called the Interstate Commerce Clause. And this body, Congress, has authority with respect to issues that involve interstate commerce as it relates to water. If you're dealing with purely intrastate water that cannot be reasonably connected to an interstate body of water, the jurisdiction is exclusively within the states. And that's the tension here. And so when you talk about issues of federalism, I agree with you, Congressman. I believe that the states are taking, and in fact have taken, I know Oklahoma has done this. We have a robust regulatory regime. I've mentioned the Water Resources Board and the DEQ working together to deal with land use and management and water quality issues. There are issues, and I mentioned one, the Illinois River with phosphorus flow that is affecting us from Arkansas, where the EPA has jurisdiction. But we should be very leery of an approach that yields to the federal government a takeover of that land use and water quality issues that are reserved to the states presently.
Okay, thank you. Ms. Van Tempel, you have something to enter for the record?
Yes, Mr. Chairman. There was a statement by Ms. Clark, I believe, that the SBA advocacy was concerned about the impact this has on small business. So I have a release dated October the 2nd from the American Sustainable Business Council stating that it appears SBA is arguing that polluting industries have the right to externalize the pollution and harm downstream businesses and communities. This organization apparently has 200,000 businesses, 325,000 entrepreneurs, executives, management. I'd like to introduce him to the record, please.
So ordered. I would like to thank our witnesses for their testimony today. Your contribution to today's discussion is very insightful and be very helpful. Hopefully, we're going to address some legislation. We can get something passed. I do believe it's the role of Congress to address this. I ask unanimous consent that the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be submitted to them in writing, and unanimous consent that the record remain open for 15 days for additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection, so ordered. Any other members have anything else? If not, the meeting's adjourned.